Did you say Ms. Davis is ready?
Yes, sir, I'm here.
Hi, Ms. Davis. Let's go ahead and reconvene and then call the next item.
This is the AT&T operator. I'm going to move you all back into the main. Just count backwards slowly from 5, and you'll be live.
Thank you.
Okay, I think we're ready to reconvene. Go ahead, Ms. Davis.
Okay, we're ready to reconvene. Our next main issue is B, appropriate methods for dealing with document submission. Invited workgroup speakers, 4 county AAB representatives, 1 assessor representative, 1 taxpayer representative. Requirements and protocols for entering all evidence electronically at or before a hearing. Timing for electronic submissions, day of hearing submissions. Protocols on presenting documents for witness impeachment. Required platform for document submission and required format for documents, example, Word, PDF, Excel, etc., ensuring parties and AAB members can view all documents during hearings and necessity for simultaneous viewing.
Great. So now we have the speakers that as I'm looking at it, it looks like we have pretty much the same speakers coming back to us. From the County Assessors or Assessment Appeals Board, we have Ms. Berkman. Now, is Mr. Parker going to do the one, or is it Jennifer Tran on this one? I'm not sure.
Mr. Chairman, this is Thomas Parker. Ms. Tran will be the primary speaker for this. I will only offer comments if the need arises from more of a lawyer's perspective.
All righty. And then we have Ms. Marvis Mazek will follow, and then we'll have Kathy McCullen. And then on the county assessors, same thing here. Don Gakel, Don, are you going to take this one, or is it going to go to Ernie?
Ernie's planning on participating on that. This is Don Gakel, Stanislaus County Assessor.
Okay. And then.
Okay.
I'm sorry?
Could you repeat that? Could you repeat that for me? I just got back on. It was late getting back.
Oh, okay. So was that Ernie I just heard?
Yeah.
Yes. So we're moving into the B item, which is appropriate methods for dealing with document submission. And the 4 bullets here, you have the 4 bullets, or you want me to repeat them?
No, I've got everything.
Okay. So we'll go through those 4 bullets, and then the last person, their taxpayer representative, will be Ms. Brennan Rabowski. So with that, let's start at the top here with Ms. Berkman.
Would you like me to address all 4 bullets or just the
Please.
first bullet?
Let's do all 4, just like we did the last one. I think it worked out better.
Okay, great. With respect to the first bullet, I will leave that to the counties that are working on remote hearings for what their clerks have found the system needs are on that. One concern that I do have that I would like to raise in that regard is, to the extent I think a lot of the counties working on remote hearings have necessary to get documents to the clerk prior to the hearing so that the clerk can upload them. One concern that comes to my mind is Revenue and Taxation Code 408. Applicants, 408 was originally intended, I believe, by the legislature for applicants to get their documents that supported their original roll value, and RTC 1606 and the related property tax rule were originally intended to allow an informal exchange of documents of certain types of statutorily enumerated information related to appeal board hearings. However, there's a case out there called Hendon where I believe that case was decided wrong. Nonetheless, it's out there. The court said that applicants can use 408 to get the assessor's hearing case in case they've looked up for hearing. And that has been sort of a long-running dispute over the last year or two that sometimes comes up. And my concern is that to the extent that for the remote hearings, parties have to submit their documents to the clerk so the clerk can upload them for the remote hearings, that I think it would be good to have guidance from the State Board of Equalization that those documents are not subject to 408. Because if they were, that would give the applicant an unfair advantage in remote hearings that they would not have in normal hearings, because in normal hearings, the assessor would be continuing to work up their documents, usually right up to late night before the case or early that morning. And it would be a tool that wouldn't be available to the assessor. And the alternative would be to say that both parties have to serve their documents on each other at the same time they send them to the clerk. But again, I agree with Carol's prior comments that there should be as much parity as possible between the remote rules and the live hearing rules. And therefore, I think the better approach would be for the board to say applicant cannot obtain documents submitted to the clerk for remote hearings by a 408 request. In terms of the types of documents, I believe PDF files would be the best way to go because they're less easily to manipulate than a Word document or an Excel document. I believe there are times when boards request that certain documents also be provided to them in Excel format, and that board should maintain the ability to ask for that. But generally speaking, I believe that the document should go to the clerk in PDF format unless there's some technical reason why the software won't handle that. And then for that next bullet, definitely all parties and AAB members should be able to view all documents during the hearings. They should be able to easily go back and forth between documents. There will be inherent issues with screen real estate, both in terms of being able to see your board members and your witnesses and your applicants and assessor at the same time, much less adding documents to it, is going to be inherently difficult. And something that everyone should also keep in mind is that while assessors are likely to be set up with their laptop and at least two large screens, and perhaps some AAB board members who are in chambers might be set up that way, people working from home and individual taxpayers are much less likely to have that set up. And therefore, while someone with a professional tax agent with that set up in their office may not be at a disadvantage as compared to an assessor, your mom and pop and individual self-represented homeowners are going to be at an inherent disadvantage just due to the lack of screen real estate and familiarity, and that's just something to be aware of. That concludes my comment.
Thank you. With that, we'll move. So for this next one, will be Jennifer Tran, right?
Yes, that is correct. Thank you, Mr. Chairman. Good afternoon. My name is Jennifer Tran, representing the Los Angeles County Assessment Appeals Board. My talking points will cover all 4 key points under this item. Effective October 2020, LA County will implement a digital workflow that incorporates efficiency, security, convenience, and the ease of use for all LA County taxpayers. Part of the IT solution is the implementation of a document management system that will facilitate digital evidence collection, collaboration, and sharing capabilities between AAB, taxpayers, tax agents, and the assessor's office. In addition to using a PC or laptop, the system is mobile-friendly, wherein access and the ability to view and upload documents can be done using any mobile or smart device. Acceptable file format includes Microsoft Word, Excel, PowerPoint, PDF, as well as JPEG and PNG for digitized images. Once the application has been scheduled, the applicant and the assessor's office will be notified of their ability to access and upload their digitized hearing-related documents within 72 hours prior to the hearing. For constituents who do not have the technology resources, they may submit their evidence to AAB at least 1 week prior to the hearing, so our staff will be able to help them digitize and upload the documents on their behalf. Both 72 hours of electronic upload and the 1 week submissions of manual evidence will allow the AAB clerk to prepare for the scheduled hearing. Please note that prior to COVID-19, LA County AAB schedules over 6,600 in-person hearings for both board and hearing officer hearings per month. Once the hearing commences, the AAB clerk will be able to virtually display the evidence submitted into record through WebEx and then share the evidence electronically to all parties through real-time access and view of the documents through this document management system. I would like to emphasize that the system also offers full capabilities to flag or identify various document types, which includes confidential exhibits or evidence. This online document repository system allows both parties to upload additional or rebuttal evidence during the hearing. Similarly, once the AAB court submits the evidence into record, the document will then be shared to both parties. This concludes my comment on this item.
Thank you. We will move on to Marvis Mazik, Chief Deputy Clerk.
Thank you, Mr. Chairman. My name is Marvis Mazik, and I am representing San Diego County's Assessment Appeals Boards. With regard to item 1, requirements and protocols for entering all evidence electronically at or before a hearing, San Diego County currently requests from all appellants or agents that exhibits and evidence be submitted to the clerk electronically 72 hours prior to the start of the hearing. This has worked well for us in terms of processing those documents, or at least uploading them, making sure that they are correct in terms of the file size, and receiving larger files that may need to be broken down into smaller increments in order for us to receive them and have them uploaded by the time of the hearing. The second bullet with timing for electronic submissions. Electronic submissions of evidentiary documents are provided or displayed to all parties during the hearing. We do not penalize for late submission of documents. However, if it is received the day of the hearing, we leave it to the board to decide whether or not to accept the exhibit. With regard to bullet 3, the required platform for document submission. Currently, we accept various forms, mainly just Word, PDF, and Excel. However, we would prefer and would highly recommend to applicants that they provide us with their exhibits in PDF format in order to maintain the integrity of the document. And for bullet 4, ensuring that parties and AAB members can view all documents during the hearings. All evidentiary documents are submitted to the clerk, as I said, no later than 72 hours prior to the start of the hearing. We use this shared screen feature in Zoom, which allows all parties in the hearing to view the documents. Also, Zoom has a feature where you can click on a participant list, which will show you all of the participants in the meeting simultaneously while viewing whatever the clerk is showing on the screen. Upon request, we will also exchange exhibits between parties via email, but only once we know that the case is actually going to move forward. So we don't provide that information, or we don't provide that exchange until the case is actually being heard, in the event that there is a potential for reset. Subject to any questions that you may have, that concludes my comments.
Thank you. Now we'll move on to Kathy McCullen, Clerk for Sacramento County Assessment Appeals Board.
Hello. On the first bullet point for requirements and protocol for entering all evidence electronically at or before a hearing, evidence and exhibits can be uploaded to the county's secure cloud from the clerk's AAB website. All documents will be retrieved by the clerk's office and downloaded to a secured location. Information that needs to be exchanged with parties will be sent by email from the clerk if the file size is small, and larger files will be sent via a secured link. Recipients will be able to download files attached in the email or from the secured link. For the next part, the timing for electronic submissions, day of hearing submissions, evidence will be requested to be submitted no later than 3 business days prior to the start of the hearing to allow for staff time to prepare meeting packets and to distribute material to the respective parties. Material is allowed to be submitted up to the start time of the hearing, which I believe might be pursuant to the R&T codes and rules. The clerk will display material on a shared screen that will be presented during the hearing. For required platform for document submissions and a required format for documents, documents will be submitted by file transfer protocol via a link on the Sacramento County's AAB website. PDF and Microsoft type documents are accepted, Word, Excel, PowerPoint, etc. I'm not sure yet about the JPEG or PNG documents. I'm checking on that. We're currently still setting up for our evidentiary hearing, so we're in the process and working with our IT and our website content team to work out the details on these things. As far as ensuring parties and AAB members to viewing all documents during hearings, the BlueJeans meeting moderator, we use BlueJeans platform. The BlueJeans meeting moderator shares the presentation screen with meeting participants. Clerk staff will moderate and present all documents during the meeting. A meeting access information and general instructions will be provided to meeting participants in advance in the form of written and electronic notification. And that concludes my comments on this.
Thank you. Now we'll move on to the county assessors. Representing the county assessors, we have the Honorable Ernie Schonenberg.
Yeah, I was listening intently to the San Diego Chief Deputy Recorder for the supervisors, and she did a good job. She covered the whole thing for us. I don't see any exceptions to what she made in the remarks, so I'm not going to be redundant.
Thank you. We'll go ahead and move on to our taxpayer representative, Ms. Brennan Roboski, the chair of CADA.
Hello, this is Brian Rabowski. Addressing each of the points, I think CADA is in agreement that from a practical standpoint, when you're doing remote hearings, your case-in-chief exhibit should be submitted 1 to 2 days prior to the hearing to allow for the exhibits to be downloaded and organized by the clerk as the board would require. We do think, however, that it's incredibly important that those exhibits that are submitted to the clerk are not exchanged to the parties, are not provided to the board any time before those exhibits are actually introduced as part of the hearing. There are various situations, rebuttal is a good example, witness impeachment, witness recollection, that will require real-time submission of exhibits and additional exhibits to be submitted real-time. We think it's important that your ability to do that is accommodated by the platforms and the rules of each counties that are doing remote hearings. To provide a very good example of a situation that you wouldn't necessarily think of, but would certainly require additional evidence or additional exhibits to be submitted. There are times in large hearings and small hearings alike where inadvertently, whether it's the assessor or the taxpayer, some minor mathematical mistake is made, or there's a page missing from the exhibit. You can think on and on about exhibit issues that happen real time in hearing persons. You would need the ability to correct those exhibits and resubmit them to the clerk. So some really core examples of real-time need. There's also the need to protect confidential exhibits. Those would have to be masked from the public, contemporaneous with viewing by everybody that's able to view them, of course, not those from the public. In terms of uploading exhibits, when a real-time exhibit needs to be uploaded, there has to be beforehand an agreed upon method to get that done efficiently. I like some of the suggestions that were made about using secure links and things for large documents and using emails to the extent that things are smaller in size. I think that that sounds like a good option to be used. In terms of timing, I think I've covered that in my comments, 1 to 2 days before for case in chief, real time for rebuttal and additional exhibits as needed. In terms of platform, we agree with Ms. Berkman that for several reasons, PDF is the best platform to be used. It allows for the protection of the exhibits not to be altered. It'll also allow for consistency across the record, as well as it really being a program that many folks are very familiar with and have ready access to the Adobe programs used to create PDF. With one exception, though, that boards should be able to request certain exhibits by Excel, by live PDF, or live PowerPoint, etc., as needed. Various situations where the boards really want to see complex exhibits in Excel as needed, that should be reserved for the boards to be able to do as needed. In terms of ensuring the parties and AAB members can view the documents during hearing, we think that this is another topic that is very, very important. The parties and the board should not be limited to viewing the documents that are being shared by the clerk, but instead should be able, once the exhibit is introduced, to view it at their leisure. So the best way that we think to do that would be creating some sort of shared site format where the exhibit is uploaded to the shared site and can be downloaded by all participants as it's introduced. And I think that covers our comments on this section.
Thank you. And thank you to all the presenters so far. This was good information. Let me turn it to the members and see if there's any questions or comments before we get into trying to arrive at some consensus here. Members, do we have anybody that wants to weigh in?
Chairman, if I might, this is Brian Rabowski again from CADA.
Sure, go ahead.
We had started a discussion last time and sort of deferred it to what I understood to be either this section or the next. And if it's the next, then please stop me and we can discuss it there. But Mr. Parker from LA made an objection to mandatory simultaneous viewing. I think I have shared CADA's concerns before that the documents need to be viewable at the same time that the witness and the entire room, including the board members, are viewable. And it appeared as though Mr. Parker objected to that. And I just wanted to understand a little bit more about precisely what he was objecting to as we move to the consensus portion of this particular agenda item.
Is Mr. Parker on the line?
I am, Mr. Chairman.
Go ahead.
The view of Los Angeles County is that we need the flexibility to conduct AAB hearings with the minimum due process required for that type of hearing. If viewing is possible, that's great, but we don't think it's appropriate to be stopped from holding a remote hearing just because the viewing element is not possible. There's no case, there's no state board ruling or regulation that says you have to be able to view. You have to be able to see the documents. You have to be able to hear what the people are saying, so you can judge and react accordingly and object accordingly as needed. But we don't believe that in terms of minimum due process requirements that the viewing aspect is mandatory. And we want to be able to, especially given the case workload we have in Los Angeles, to be able to use remote hearings as needed to make sure that taxpayers get their day in proverbial court and that we get the hearing done and we've done our job as an AAB.
Okay, is it Ms. Robowski?
Yes.
Is that pretty much explain where they're coming from, or did you need more info on that?
I understand the statements that Mr. Parker made. I'm wondering if he's reserving the ability for telephonic hearings. And the reason I'm a little puzzled is that most platforms that we've reviewed, and I apologize if we've missed something in our tech review, but would allow for viewing of exhibits and viewing of participants simultaneously. I believe that the clerk from LA referenced WebEx, and at least in what we were seeing available online, you would be able to accommodate simultaneous viewing. So I'm just trying to make sure I understand the objection in full. Is the idea that you'd see the document but not the witness, or vice versa? I'm just trying to understand the details a little bit more so we can formulate a position and move to consensus if possible.
Well, I appreciate that, Ms. Grabowski. First off, we view what we call administrative hearings. The hearings are referred to in the morning testimony. We view those as the types of hearings that you could do purely telephonically, like we're doing this hearing today. Again, STIPs, recommendations, approving withdrawals or notifying of withdrawals, reading and facts, findings of fact. All those, even a simple conference telephone call could do, as long as everybody's on the telephone call. That's a very simplistic, or a status conference, very simplistic type of hearing. But if for some reason, on what I will call an evidentiary hearing, whether it's a simple real estate value type of appeal, or whether it's the most complex commercial property case known to mankind, if the only problem is that viewing the individuals, I'm not talking about documents now, but if viewing the individuals is the only problem that cannot be overcome, we don't think that any of the parties are being denied due process. And we feel at the LAAAB that we should have the flexibility to proceed with that kind of a remote hearing on evidentiary hearings. I hope that clarifies things.
Yes, this is Brianna Rabowski. That definitely does clarify things and is very, very helpful. I think, unfortunately, that's not something we could consent to with respect to evidentiary hearings. I think administrative hearings, as you've suggested, Mr. Parker, potentially could be done telephonic because there's not a need for the board to really be assessing witness credibility or making factual determinations. But for evidentiary hearings, I think the concern of CADA is you have to look at the role that the board is playing in a broader perspective. The board is being asked as a constitutional quasi-judicial agency to make factual determinations that will then be given great deference in any appeals to the court. And so effectively, the courts are saying whatever factual determinations the board makes outside of substantial evidence to the contrary, or no support of substantial evidence of that determination, we accept the factual determination that the board has made. And there's quite a lot that we're asking the board to do when we ask them to make those factual determinations. And we think that it's part and parcel that the board be able to assess witness credibility when they're making those determinations. And we fear when you can't see the witness in any evidentiary setting, but yet you're asking your board members to make factual determinations upon which the court and all participants will give great deference and appeal, you aren't providing due process throughout the procedure. And so we think for evidentiary hearings, if you can't see both the witness and the exhibits along with the board members, you aren't affording due process to that hearing format.
I understand. This is Thomas Parker from Los Angeles. I understand where you're coming from. I'm not sure what else I can tell you or the board at this moment.
Okay. I think I heard, was that Regina?
Yes.
Go ahead.
There are other parties at the table. I'm just curious if we could hear from them. Miss,
Sure.
I think Miss
Is Ms. Berkman still on?
Miss Tran, Miss Berkman, I'd love to hear, or Miss Evans.
This is Marcy Berkman. I agree with Brianne's position.
I'm sorry, Marcy, I didn't hear you.
Hi, this is Marcy Berkman. I agree with the position that Brianne articulated.
Thank you. Others?
This is Marvis with San Diego County. I also agree that in terms of administrative items, it would be beneficial to be able to move forward without video. However, with evidentiary items, I think that it would be, it would help all parties involved if video was available.
Thank you.
This is Jennifer Tran from LA County. We understand the need for visual representation as well as the ability to view the evidence in real time during the hearing. However, there may be constituents who do not have the technology resources such as a webcam to be able to, present themselves, to show themselves to the board and the assessor's office representative during the hearing. I just want to mention that we do have designated areas where it is fully conference, web conference, or virtual hearing ready, or have the necessary technological equipment needed. And our board members will be fully equipped with laptops with built-in camera and extra monitors for bigger screens to be able to view the evidence clearly during the hearing. And I just wanted to address one more thing regarding Kata's concern to make sure that evidence is shared during the hearing. Our document management system that is currently being developed will have the protocols and security to make sure, this won't, that the clerk will have full administrative access to only share the evidence to all parties during the hearing. And like I mentioned earlier, upload of new documents and rebuttal evidence is available during the hearing. And just to provide additional security, each record or application within this document repository will have a full audit trail of whoever accessed and the date stamp of when it was last accessed or document was uploaded into the system.
Thank you,
Regina?
Mrs. Tran. I just have to apologize. The comments made by Mrs. Robowski related to being able to view all parties, can you restate your position again?
Yes, I think the position is with respect to administrative hearings, telephonic formats may work. Evidentiary, we believe that it would need to be by video, and that it's important that you be able to simultaneously view not only the witness, but the evidence, as well as the board members. And the real crux of that is the board's ability to assess witness credibility in making their factual determinations. And without that, due process cannot be afforded.
Regina, this is Marvis from San Diego County. Can I just ask, as a caveat to that, would it be possible to include something where if, and maybe this is actually for Kata, if all parties are in agreement that they are willing to move forward without video, is that acceptable?
I think that's a good comment, but before we get there, I just want to ask Tom Parker a question, if possible.
Go ahead.
I'm here, ma'am.
Tom, I'm just wanting to make sure I appreciate, do I hear you and Ms. Tran giving us two different perspectives for LA County, or are you saying the same thing?
Ms. Tran is trying to quite properly emphasize the degree of technological access that LA County plans to give to individuals, especially in terms of documents, which are extremely important in terms of the record of the hearing and the basis for whatever decision comes out of that hearing. So I was focusing more on the general due process position of Los Angeles County AAB and trying to explain the basis for that. And Ms. Tran was following up in the same vein from the practical, operational, planning, and technological end in making sure that the board knows what we are doing to try and make sure that the important access that is required by due process is given to everyone.
Thank you. Just one additional follow-up question. So Ms. Tran communicated, if I heard her correctly, that from the seat she sits in, when it comes to evidentiary matters, that having the ability to see and view all parties is important, and I won't put any words into her mouth, but I think I heard some agreement as it related to all other parties but yourself for evidentiary matters. Or did I misunderstand that?
I hate to put words into her mouth. I didn't understand her to be saying quite that.
I'll go back to Ms. I'm sorry. I'll go back to Ms. Tran. What I was just stating, Tom, is I thought I understood everybody. I'm sorry, Mr. Parker. I thought I understood everybody to state Ms. Mazak, the representative from Sacramento, and I know the name I have on my paper is not accurate, as well as Ms. Berkman. And I thought I heard Ms. Tran state that for evidentiary matters, it is important that all parties should have the ability to view and see each other in the hearing. And yes, we all understand that things can occur that just make it not possible, but then parties have to address that on a case-by-case basis. But overall, that's our objective going forward. Did I hear that correctly, Ms. Tran?
Well, I think that was Ms. McClellan who said that from Sacramento, and I'll invite her to correct me if I'm wrong.
Yeah, I was asking Ms. Tran that question.
Hi, this is Jennifer Tran. So basically what I was trying to refer to is that we understand the need to be able to see, the parties during the hearing. However, we should not restrict or disqualify those taxpayers who may have IT resource challenges, such as, they may have a computer, an old computer or an old version laptop that doesn't have a built-in camera. However, we are accommodating such needs for LA County, whereas we do have designated areas that is fully equipped for web conferencing or virtual hearings. I hope that clarifies my statement earlier.
Understood. Mr. Vasquez, I don't think I have any more questions on that issue.
Thank you. Member Gaines or Vice Chair Schaefer, is there any other comments or questions?
I do, if I could. This is Member Gaines. Is that all right? Yeah, I've just got concerns about a hearing that doesn't have any video or viewing aspect to it, and I just do not think that you'd be treated in a fair fashion if it was just a teleconference call. And because it is quasi-judicial, I think some of these cases could be very, very important, and I just want to make sure that people were treated with the same level of due process. And I keep thinking of a trial attorney making his case to a jury over the phone, and you're just not going to get the same impact. There's no way. And some of these cases, I think, could be $1 million decisions, and to not treat it at the same level, in my view, is just a mistake. So I think there should be the video aspect, and I would also say the in-person hearing also. But if we're just talking about technology right now, I think that video ought to be included. Thank you.
As Vice Chair Schaefer, I would second Member Gaines' views.
Okay. So at a bare minimum, it sounds
Ms. Stowers here.
I'm sorry, Ms. Stowers, go ahead.
Yes, I'm here. I'd like to say that you definitely, in order to have a meaningful and timely hearing, especially when it comes to evidential hearings, that you should have a video aspect of that. But what I'm hearing from LA County, from Ms. Tran, is that at least LA County has made, or is in the process of making arrangements for those taxpayers who do not have the technology to have video. They will have a virtual video room for them to come to, so that their due process will be carried out. So I just wanted to kind of reiterate what I'm hearing about LA. They have gone beyond. They recognize that some taxpayers may not have the resources, so they are providing for them. I don't think that this board can mandate for any county to do that, but I do commend LA County for taking that added step.
This is Thomas Parker from Los Angeles. I thank you for the latest comments, and I certainly do reiterate that we are going out of our way to create a place with all the necessary equipment and assistance for individuals. I would also just throw a rhetorical question out there to make a point, which is, if you have a visually impaired AAB board member, even in an in-person hearing, that AAB member is not going to be able to visually view the witnesses and make a determination about the credibility of that witness. That visually impaired AAB member is going to rely on, say, Braille documents, their ears, the tone of the voice of the witness, and make whatever credibility conclusions they ultimately reach. I raise this only to make the point that there's more than one way to determine credibility of witnesses, and being able to see them while nice and convenient and the very common way to do it, is not the only way. Thank you.
Thank you. So it sounds like, at least from the members and even some of the panelists, that the number one priority, I guess, would be to at least get a video if we can't do something in person, is what I'm hearing. So I'm not sure there's a consensus from all the parties.
Chair Vasquez?
Yes.
This is Don Gakel, President of the CAA. I just wanted to comment that as an assessor, appraiser, and participant in board hearings, not so much anymore, but in the past, I would certainly want in a virtual hearing to have a video component, to be able to see documents, to be able to see the participants. However, and I think all appeal boards doing virtual hearings should be set up to accommodate all of that. However, and I think I heard it from San Diego County Appeals Board that, should there be a technological issue or some kind, or a video failure, I think that the board and the participants in a particular hearing should have the ability to make a judgment at that time, whether they're willing to continue, or, as we've previously discussed in another section, if the hearing would be continued to a later date or some other action taken. But I think it's important that in the basic setup and going in, that video, audio, ability to see all the participants, ability to see all of the documentation should be the setup that everybody is striving to use. Thank you.
Mr. Gakel, so is it fair to say that, I know you represent all counties, and I'm thinking when you're representing the small counties, is it fair to put that on? I'm wondering if they have that capability with the video.
Well, I mean, I'm saying when people are, if you're putting on virtual hearings, I don't think there should be any requirement that you have to have virtual hearings. As a matter of fact, my own county is not doing virtual hearings right now. We're doing in-person hearings with social distancing. Our clerk is discussing the possibility of virtual hearings now, because some taxpayers are requesting that capability. I think for a lot of the smaller counties that their appeal load is significantly smaller in most cases than the larger counties that are participating here today. And I suspect that most of them will be planning to proceed with in-person socially distanced hearings. But if they're going to have virtual hearings, yes, I think they should have video component and the ability for all participants to see the board members, the assessor representative, the appellant, yes, I think I can go out on a limb that far to say that if they're having virtual hearings, they should do that, but in no way should they be required to have virtual hearings.
Well, what if we said that if they can't do the virtual hearings, that it has to be in person, like you mentioned, with social distancing and the like?
Well, I think individual counties will make that choice. But I think what we're talking here today is trying to set up standards for if a county is participating in virtual hearings.
Right. So if they are doing virtual, it should have that video component to it, basically.
Yes.
Okay.
Again, with the caveat that the parties to a particular hearing can make a determination if there's something that doesn't work out at that time.
Okay. Any other comments from other members?
Mr. Vasquez, I'm wondering if there's any consensus in some of these areas.
That's what I was going to get to. It sounds like now, after listening to Mr. Gayko, that I'm wondering if it's fair to say that there's a consensus that if you're doing the virtual hearings, that they have to have that video component to it.
Chairman Vasquez?
Yes, go ahead, Ms. Stowers.
Could you add on to there with respect to evidentiary hearings, you have to have a video component, but not so much for procedural hearings?
Sure.
I do believe the parties agreed to that.
Sure.
Yes, this is Don Gaykel. I would agree with that as well.
Okay.
I think that's a good point by Ms. Stowers. I'm wondering, Mr. Vasquez, Ms. Masick from San Diego was offering up a recommendation for us to consider. Is it worth hearing from her at this time as it relates to that issue?
What was the recommendation, Ms. Masick?
This is Murphy Smazek. I think Mr. Gaykel actually referenced it, wherein if all parties are in agreement, if there is a technical issue or for some reason video is not available, however, all parties involved are in agreement that they would like to proceed with the hearing, that they would be able to do so.
Who's that? I'm hearing somebody in the background there.
That was what San Diego Assessor's Office was going to agree with. That you can waive it if both parties agree.
Okay.
What about everybody else, Mr. Vasquez? I'm just curious if we're capturing what the rest of the work group is willing to embrace, understanding that we're trying to get to consensus.
Do we have anybody else out there that wants to weigh in?
Yes, this is David Young,
David,
Director of the Property Tax Department. If I may just add, I think the issue is a little bit more basic than this. I don't know if there's much disagreement with should there be a video component. I think the answer to that is yes. I think the question is, must there be a video component? If there is no video component, does that impede due process to the point where it's no longer, I mean, it violates due process? If both sides agree to it, then I guess that's not an issue. But if one side disagrees with it, the question comes back: is that enough? I mean, if it's not enough, then you can always ask for a continuance or a continuance of the hearing. But I think Mr. Parker's question is, the lack of a video component is not enough violation of due process to basically say the hearing is not valid.
I think we had some board members kind of express some concerns, Mr. Young.
Yes.
In that space, I think Mr. Gaines in particular.
Right.
So
This is Vice Chair Schaefer.
Go ahead, Mr. Schaefer, Vice Chair.
I'm concerned that we have such different districts. Your district, Mr. Chair, is LA and Ventura County, and those are humongous groups, large interests, millions of people. Mr. Gaines, Member Gaines, has lots of small counties, as does Ms. Cohen. And in these smaller counties, we got to be very careful that we don't adopt rules that are going to be very difficult for the small counties or are going to infuriate some of them from stuff that they've been doing in the past that seems to have worked pretty well.
Yeah.
I just want us to always keep that in mind. Thank you.
No, I agree. That was my question to Don Gayko, when he came out. I was trying to get a feel, since he represents all small, medium, and large counties.
Yes.
If there was a consensus. And I thought I heard, unless I misheard, I thought I heard from him that if they're going to have them, they should have a video component. But then I'm hearing David, our staff, saying that, does that mean they have to? I guess that question of must in terms of a legal
Yeah,
term.
I thought, Mr. Vasquez, I thought that issue was previously addressed in your comments, Ms. Stowers' comments, as well as in Mr. Gagel's comments. And I think even Ms. Mazak, when she offered up her suggested language, and I guess the real question is, are there any parties who are on the work group or any board members that sort of have concerns about what's being proposed?
Yeah, this is Member Gaines. If I could just reiterate, it seems to me that the taxpayer ought to have the flexibility on deciding whether they would want a hearing over a teleconference versus video. But I don't think it ought to be open-ended. If a constituent wants a video hearing, I think that the county ought to oblige and do that. I think there's so many situations where there can be confusion as to even who's speaking in a teleconference. We suffer from that problem here in trying to take public testimony and trying to clarify who said what. And I just think that there's so much more clarity and would be a better satisfy the requirements of due process, the way I view it at least, in having that video aspect.
Mr. Gaines?
Go ahead, Ms. Evans.
Yes.
Mr. Gaines, just so I'm clear, are you saying that you believe the video conference option should be available for both administrative and evidentiary hearings, or are you speaking specifically to evidentiary hearings? Because I think we hear the work group making a distinction.
I think both. Yeah, I think both. I think there could be circumstances that have already been described where maybe someone doesn't have adequate video, and maybe the lighting's not right, maybe the volume's not right, so maybe you're not getting the right evidence. Maybe the case would not be heard in a fair manner without having the right standards, which is what we're really meeting about, right? What are the standards in terms of having a high enough quality of video conference, but that would also apply to a teleconference. But if you have a taxpayer that says, hey, I'm comfortable with a teleconference, I think that's fine. But I don't think the jurisdictions should dictate to the taxpayer on how they're going to present their case.
I'm curious, that's an excellent point, Mr. Gaines. I'm curious to some of the representatives on the work group. How do you hold administrative hearings now that may not be by video, and how does the taxpayer agree or participate? Maybe you can give us some perspective of how that works today, even before the pandemic, I would think.
This is Kathy McClellan from Sacramento County. We have had several STIP agreement types of hearings, and we always, the taxpayer, the agent are notified of this, and these are all by teleconference, and we don't say anything about it being by video. We do tell them it's a teleconference, and they have every right to call in. We give them the information, and they have thus far have all declined to be a part of it. And so it's just been between the appeals board and the assessor's office. And so we haven't had any issues or requests for video conference or any any negative feedback or, that they've disagreed to hold a teleconference or that they've requested the video conference or an in-person hearing.
Thank you. Are there others on the work group that could weigh in and just give us some perspective about real life and procedural matters?
This is Marcy Bergman. In Santa Clara County, many of the types of things that it sounds like other counties have their appeals board handle, our local rules delegate to the clerk to handle administratively. So for example, postponements of hearing dates, processing withdrawals with the exception of 2 situations specified in our local rules, and such things that many other counties handle at their AABs, our local rules delegate to the clerk so that there's no need for an administrative hearing. For our stipulations, the notice of hearing lets the applicant know that there's, the board will be considering the stipulation on a particular day, and that they are able to attend the live in-person hearing if they want to, but that it's not required. The parties almost never bother to come to the stipulation hearings on their value stipulations. And so what the board does is it reviews them, and if it approves them, it waives the appearance for the parties. And in the event that there's additional questions and information they need before approving the stipulation, they'll let the assessors know, office know, and put on the record that they need a certain amount of more backup information. And on rare occasions, on a very complex matter, the board might continue a hearing to another date and ask that both parties appear to answer questions and provide some more information they need. But mostly, 99% of the stipulations are just live in person for the board, and the board waives the appearance of the parties. So we have far fewer of the administrative type hearings that some other counties might find appropriate to do telephonically or via video. From my experience as a litigator in Superior Court, Superior Courts will often conduct status conferences or pre-hearing conferences where one party or the other opts to appear telephonically. That's totally up to them. They sign up for court call if they want to do that. And I think that it works just fine for that process. As a former big law litigator, I was always trained that it's always to your client's advantage to be there in person, but it is certainly your option to decide to appear by court call, and it seems to work well. Sometimes the person on the phone doesn't hear as well as the other person and have a clear view of what's going on. But for the administrative type things, I see courts use that all the time.
This is Tom Parker from Los Angeles. My experience is much the same as Marcy's, and LA County AAB for years now has been doing those administrative hearings with little or no participation from the parties because they have agreed to the value in the case of a stipulation or a recommended value or a withdrawal of the appeal. So the parties, for those kinds of administrative hearings, the parties, for the most part, see little or no need to show up just to see happen what they know is going to happen. And as Marcy said, in Superior Court, status conferences, trial setting conferences, those sorts of things, they are done by telephone.
Question, if I could, Member Gaines? I'm wondering.
Go ahead.
Yes, sir.
Yes, thank you. I would like to hear from Brianne Robowski if she's still on.
I am, yes.
Yeah, could you just express, what your thoughts are on this issue?
Sure. I think for administrative hearings, the bulk of them could be done telephonically without a video component. I can't imagine situations where what seems like a routine value recommendation turns into something that requires evidence to be submitted to the board or further argument required for the board to fully understand and vet the issues. But I think by and large, these things could be conducted telephonically.
Okay, so can you clarify that? Does that mean that the taxpayer does not get the choice. Are you comfortable with the taxpayer not getting the choice in those cases?
I think so long as it's non-evidentiary. If, for example, a valuation recommendation takes a turn that the parties aren't anticipating and the board would like to hear evidence before making a decision, then a video component becomes very important because you're defending that value recommendation and evidence will be submitted. But non-evidentiary, I think telephonic is adequate.
Okay. Very well. I'm comfortable with that. I just want to make sure that taxpayers are protected through the process, and CADA is dealing with them every day. So I'm comfortable with that. Thank you.
Yeah, and I very much appreciate that. I did want to just clarify our position on the evidentiary hearings, if that's okay. But I'll pause to see if that's the appropriate course that the board would like to take.
I'm wondering, thank you, Brianna. I'm wondering, Mr. Vasquez, based on even Mr. Gaines' follow-up questions, is it sounds like we could probably get to some level of a consensus on the administrative piece, but on the evidentiary piece, there's probably some work that we need to still do. And I'm just wondering if we should decide to table this to our next meeting and maybe look at the items in the section where there may be some opportunity for consensus.
Well, you know, now that you brought that up, I was going to ask, at least from the presenters, do any of them feel like there may be a consensus that they want to at least put on the table and see if everybody is in agreement with?
Well, Mr. Chair, this is Thomas Parker.
Yes, go ahead.
I perceive there is, from Los Angeles, I perceive, and I hope I'm correct, there is consensus upon submitting documents electronically prior to the remote hearing commencement. I'm hearing either 72 hours or 48 hours from the testimony today. I think there would be consensus about allowing rebuttal documents to be entered into the remote hearing as the side seeking to introduce those rebuttal documents believes it appropriate to do so. I hope I'm right about that. I think as well that I think there is consensus on the idea that the documents submitted in advance by the parties in a remote hearing would not have access to the record, to the documents of the other side until the commencement of the hearing, although one wrinkle there would be as the party seeking to introduce its case-in-chief document introduces its document. And I think there could be consensus there, but I'm glad to be educated if I'm wrong.
Okay. How do the other members feel about at least those? And I think I agree. I think I was kind of hearing the same thing on the hours. It sounds like there's definitely consensus of 48 hours, and there may be for 72. I wasn't sure if people were comfortable with 72 hours prior.
This is Marvis Mazik from San Diego County. We are in favor of 72 hours prior to the start of the hearing for electronic submission of documents. However, I think it would be agreeable as well that we have those documents that are submitted to the clerk via U.S. mail at least a week in advance.
Anybody else want to weigh in on that?
Yes, this is Jennifer Tran with LA County. I concur also with the 72 hours electronic submission of evidence prior to the hearing, and for paper or manual evidence, for those to be submitted to AAB at least 1 week prior to the scheduled hearing.
Okay. Anybody else?
This is Brianne from CADA.
Sure, go ahead.
I think that in addition to the items that we're discussing, there needs to be an ability to add exhibits as the need comes up. So not limiting that simply to rebuttal exhibits, but things like correcting errors in exhibits, impeaching witnesses, those sorts of things should be layered into this recommendation. In terms of timing, I think that 72 hours is a big shift from where we currently sit. Many different members of the working group have stated that we should be mirroring as closely as possible what happens in person. And we know from those hearings, you simply pull out your exhibits as they're introduced. So I think that 48 hours for the bulk of the exhibits would be as early as we could do, with a strong preference for the night before. I do worry a little bit from a legal aspect that requiring printed documents a week before, but electronic 72 or 48 hours puts smaller taxpayers at a disadvantage, since those are likely the taxpayers to be using the print model. I think there are situations where large taxpayers will have complex exhibits and they'd want to submit those as well, with tabs and binders and those things. And a week before simply isn't always doable. So I guess taking a step back, I think there needs to be some flexibility on the timing depending on the case and the issues. And the last thing I'll say is I think it's incredibly important that there not be an exchange of exhibits at the beginning of the hearing, but rather, again, as Mr. Parker recognized some parties were saying, it has to be as things are introduced and no sooner than that.
Okay, anybody else?
Kathy McClellan, Sacramento County. I'm prepared to agree with the 72-hour electronic submission, but have not had a chance to discuss with staff on the U.S. mail submittal. So, but I agree with the 72 hours.
Anybody else? How about, actually, I'm going to ask Brenda, our executive director, if she would weigh in on this one as well.
Before we get comment from Brenda, Mr. Vasquez.
Sure.
I was wondering, it would help me, I don't know if it will help the rest of the board members. The 72-hour requirement, is there anything like that currently out there now? For some reason, I recall some counties require that today. Can anybody speak to that?
Yes, this is Marvi Smazik with San Diego County. We currently request that exhibits or evidence be submitted to the clerk electronically 72 hours prior to the start of the hearing. However, as I stated before, we don't penalize for late submission of documents. However, if it is submitted the day of the hearing, then the board will decide whether or not to accept the exhibit.
And Ms. Masick, does this just apply to your remote hearings, or did this apply to your standard hearings that were held in person?
This applied only to the remote hearings.
What was your requirement prior to remote?
It was done during the hearing.
Done during the hearing. And then can you just share with us why the 72 hours? I'm sure there's some rational and reasonable basis for that decision.
Mainly for what we would consider processing, uploading the documents, ensuring that the correct documents have been received. Some of the file sizes are large, and depending on the amount of items that we have on an agenda, if we have, say, potentially 200 cases on an agenda, that's potentially 200 sets of evidence that we could receive. So that gives us enough time to make sure that we upload and properly process all of those evidentiary documents for viewing by the board and all parties involved.
Thank you. Others?
Could I comment? If
Sure,
Ms.
go
Evans, if you were finished.
Let's go ahead.
All right, great. Thank you.
I was hoping to hear from other parties, but if Mr. Gaines is asking questions along the same lines, I'm comfortable.
Yes, I am. Yeah, I think your questions are good, and I just wanted to get some input, if we could, from Don Gakel on that very issue that Ms. Evans brings up in terms of, what are the timeframes for a virtual meeting, and then what were they prior to virtual meetings?
Well, I can only tell you, this is Don Gakel, Stanislaus County Assessor. I can only tell you what our past practices have been. Again, we have not started or done any virtual hearings, so I can't comment on that. At one time, our clerk of the board required that we submit our written presentations 7 days in advance, and that was for in-person hearings. The unfortunate part is that they didn't require the same thing of the appellant. Okay. And eventually we stopped that for a couple of reasons. One, we think it's clear that the board is only to consider information that they receive at the hearing, and the board was having a week to look over our documents. And in fact, we thought it was a net benefit to us, but we didn't think it was very fair to the taxpayer. Mm-hmm. And so we changed, and we submit our documents at the hearing. So the board members don't have a chance to see it ahead of the actual hearing. Mm-hmm. Requiring submittal 3 days in advance for electronic or virtual hearing would be a change of our practice.
Okay.
But I'm assuming that what the clerk is doing is assembling that, but not distributing it to the board members at the time. So mm-hmm. I wouldn't have an issue with it as long as it's not actually being presented until the hearing, as previously discussed by other participants.
Okay. All right. I guess in terms of submission of information, that 72-hour rule seems a bit long in terms of the amount of time prior to the meeting, and I would be in favor of looking at a shorter time frame for that.
So this is Brenda Fleming, Executive Director. Just to weigh in a little, if I can offer some of the staff's thoughts about this.
Sure. Go ahead.
We definitely want to offer as much flexibility as possible. So from a uniformity perspective statewide, we can certainly look at, as I think I've mentioned before, our guidance in terms of best practices. But we definitely want to offer some flexibility both for the taxpayer side and also for the county side. What we're thinking about is we could use some language that doesn't let me back up. So to the extent that we are too specific with the time frame, potentially could require us to do require regulation, which might, to add more time to it. So again, we'd like to be as flexible as we possibly can. We're playing with some language to the extent that we might say should try to, or something like that in an LTA. It sounds like everyone's okay with giving some time frame to in advance of the hearing to get some of the material. And I appreciate what was said in terms of what comes in written form versus what comes in electronically. It's kind of two different paths. So I appreciate the fact that for the hard copy versions of it, the handling of that material, it may take potentially a little bit longer to process and review, but I'm also sensitive to the burden that puts on the smaller taxpayer. So again, we're trying to be as flexible as possible here. And we're doing this right now at the top of our heads as we're analyzing what we're hearing. There's some other thoughts that we need to think about in terms of best practices, in terms of Documents in PDF are generally going to be needed. We've heard some of that. You've got to think about how you're going to process that. Will be more general again, because some of the smaller counties may or may not be able to accommodate it clearly the same way that larger counties do. If there's questions about the documents, the process for the material to go back and forth in advance of the hearing, we find it now with our current hearings here at the BOE for these type of hearings. We often receive material and oftentimes have to go back to the submitter of the documents and get some clarification, et cetera. So you do want to allow some time for that level of process.
Mm-hmm.
So at this level, I think where we're hearing as some consensus is that it would be appropriate, and it sounds like everyone's comfortable with giving some advanced time for preparation for the material. We would just be looking at it from our perspective of doing something that doesn't require any regulation changes unless we're looking at more longer-term work. But for something in the short term, again, we would be in the lane of more best practices kind of guidance that gives you flexibility while, again, still being sensitive to the taxpayers.
Chair Vasquez, if I may, I certainly appreciate Ms. Fleming's remarks, but I don't think we have consensus in this area. And I'm just wondering if this is an issue we should punt to our next convening. We certainly have heard all the issues. I think the information has been extremely valuable. We've heard a lot, but I think there's an opportunity to really spend more time with the work group and figure out what we can actually do in this area. And this just should be an area that we might want to remain silent on for now.
No, I agree. I was going to raise the same issue. I think you hit it right on the nail. I think we have enough info out there, but obviously it doesn't seem like there is a consensus. So I was going to suggest that maybe we just move on to the next item. But before we do that, we should allow the public, if there's any public comment out there, to weigh in if they want to. And I would turn to Ms. Davis or AT&T for that.
Happy to, sir. Ladies and gentlemen on the phone lines, if you would like to weigh in on public comment at this time, you may press 1, then 0. Does not appear anyone is queuing up at this time.
Ms. Davis, do we have any? We don't have any written comment on this, do we? It doesn't appear we do, right, Ms. Davis?
Hi, this is Acting Board Proceedings Chief Henry Nanjo. I'm not aware of any written comments. Thank you.
All right. The members, we'll go ahead and table the rest of this, and let's move on to our next item, which is C, which is technology options. And for this one, we've invited a work group speakers for county AAB representatives, 1 assessor representative, and 1 taxpayer representative. The 4 bullet points on this one is visual or auditory interruptions, freezing or dropped links during hearings, remedies to ensure all parties have access, alternative options. The next bullet is reliable platforms for remote hearings, like Zoom, WebEx, etc. Addressing bandwidth, other solutions to consider. The 3rd bullet would be notice requirements to parties, access instructions, coaching/training videos, accommodations for special needs. And then the 4th bullet would be investment in remote hearings capability, efficiencies realized long-term. And with that, we have the following speakers. Under the county, we're going to use Ms. Berkman again, Ms. Tran, Ms. Mazek, and Ms. McCullen. On the assessor's representatives, I believe it's going to be the Honorable Don Gakel, or it may be Ernie Dronenberg.
I think
I'm sorry?
Ernie Dronenberg is planning on presenting, so.
Okay, so we'll have Ernie on that one. And then the last one on the tax revision, we'll go back to Ms. Brennan Robuski, Chair of CADA. With that, let's begin with the first one. If we can have Ms. Berkman to address the first 4 bullets on technology options.
Thank you. I concur with the bullets that laid out. It's very important to be aware of and plan to handle situations, because they will happen, where one or more parties or board members or the clerk has a freeze or drops out, and that this may not be immediately evident to other people in the room, and it should be planned for how to handle that. The platform is probably, once it's determined what's to be available, for example, that everyone should be able to be seen on video as well as the documents, I think there needs to be the flexibility for each individual county to use whatever platform technologically they can that meets the requirements. And of course, that all people involved have sufficient notice of what's going on and the training. One thing that the board might want to consider would be recommending in its guidance that there be a set background, either provided by the board or provided by each county, that each person could put up on their video screen, so that the video that's being shown to the world and preserved for posterity and seen by people is, first of all, as formal as the hearing room, and second of all, not invading the privacy of people's homes, where people can peer into that, and perhaps creating implicit bias based on the conditions of those homes. So that's a possibility of something that might want to be considered. And then one other aspect that might be useful for guidance is, in some counties, it might be conceivably the situation that you have your normal hearing room tape that is your usual record, and now you're going to have this remote video recording. So perhaps a recommendation that the individual counties have a local rule or procedure specifying what constitutes the official record when you conduct a remote hearing. You know, whether it's the Zoom or WebEx recording straight from that, or a video recording that the clerk, audio recording that the clerk is making in the room, just so that there isn't some later fights between the parties over what the official record is in those circumstances. Thank you.
Thank you. Ms. Jennifer Tran.
Thank you, Mr. Chairman. This is Jennifer Tran, once again representing the Los Angeles County Assessment Appeals Board. My talking points will cover all 4 subtopics under this item. LA County's IT solution for virtual hearing is guided by our workload and current resources, wherein virtual hearings can be easily accessed using a PC, laptop, or any smart device with internet or Wi-Fi access. As you know, LA County far exceeds the volume of AAB applications received compared to other jurisdictions within the state of California. Based on the last 3 filing years, we received an annual average of over 18,000 applications with over 25,000 parcels. Therefore, LA County AAB needs a degree of flexibility to deal with the county's circumstances. Currently, LA County utilizes WebEx for our administrative hearings, and will continue to use this platform for evidentiary hearings coming up in October. When AAB began conducting administrative hearings in April 2020, we have experienced minimal auditory interruptions, wherein the taxpayer or tax agent would have poor Wi-Fi or cellular signal connections. In that situation, the AAB clerk would call the taxpayer or agents through their landline for better audio connection. In addition, AAB board members and hearing clerks have been provided with headsets with microphones with noise cancellation features to ensure outstanding and clear audio quality. As we move on to virtual evidentiary hearings in October, if there is a connectivity issue that would impact the visual component, particularly with evidence presented at the hearing, the AAB board members may exercise the right to continue the hearing at a later date pursuant to Assessment Appeals Rule 323C. As mentioned earlier, AAB board members will be fully equipped with laptops with built-in camera and speakers, as well as extra monitors for bigger screens or real estate to view the evidence during the hearing. In preparation for the upcoming virtual evidentiary hearings next month, we are also developing instructor-led training curriculum and reference guides for AAB board members, hearing officers, AAB clerks, and the assessor's office for WebEx and document management system trainings. In addition, we are developing comprehensive, with illustrations, trifold reference guides for both WebEx and document management system, which will be mailed to the applicants and tax agents with their formal hearing appointment card. These reference guides will also be made available or posted on our public website. Lastly, AAB staff will be fully trained on both systems to provide basic troubleshooting support as needed. With our county's diverse socioeconomic landscape, we remain cognizant of digital accessibility and literacy and the need to ensure that every community has a fair and equal access to a fair hearing. To assist our constituents without access to technology resources, accommodations will be made. AAB offers designated areas that are fully teleconference capable and compliant with the public health safety measures and guidelines. These designated areas will be equipped with a laptop with built-in camera and microphone, Wi-Fi or internet access, a telephone line, as well as a printer with scanning capabilities. An AAB staff will also be available to assist the taxpayer as needed. As of September 21st, LA County AAB has a cumulative total of approximately 45,000 open applications with over 46,000 parcels. Just for the current filing period alone, we already received 6,500 applications with over 7,000 parcels. As a long-term solution, once the COVID-19 safety and health restrictions are lifted or no longer in effect in LA County, our county would like to continue a hybrid approach using both in-person and virtual hearings. Currently, our boardrooms are fully equipped and in compliance with the health and safety protocols, including safe social distancing and plexiglass. And this concludes my comment on this item. Thank you.
Thank you, Ms. Tran. With that, we'll move into Ms. Mazik, Chief Deputy Clerk from San Diego.
Thank you, Mr. Chair. This is Marvis Mazik with San Diego County. I will also speak to all of the bullets in one summary. So with regard to our visual and audio...
A point of order, Mr. Chair, Vice Chair. Could you ask the speaker to please speak up? I'm having trouble hearing her. I don't know if it's a microphone or maybe she's just not as strong voice as we're used to. Thank you.
Sure.
Are you able to hear me now?
Is that better or a little bit louder, Ms. Vice Chair?
Are you able to hear me now, Vice Chair?
It's better. I just want her to be aware of this problem I've had all day with her presentation. I turn up our volume here on my set, and then when she's finished and her normal voice comes in, it is bombastic. And so I just thought if she could speak a little louder, or if you have the magic, technically to give a little boost to her voice, I think we'd all appreciate it. Thank you.
Thank you.
All right.
So
Go
with
ahead.
okay. With regard to assessment appeal hearings in San Diego County, in the event that there is a visual or auditory interruption, the chair will request a recess to troubleshoot the issue. We have experienced one issue where participant connections were dropping, and we handled it this particular way, where we either take a recess or we table those items to the end of the hearing so that the issue can be troubleshooted. In the event that it cannot be resolved, then the case is reset to the next available hearing date. We are currently using Zoom to conduct our virtual assessment appeal hearings, our county hearing officer appeal hearings, as well as our Board of Supervisors meetings. We have worked with our IT vendor to increase the bandwidth capacity for virtual Board of Supervisors meetings and can utilize that same functionality for our assessment appeal hearings. Our access instructions for the Zoom meetings are provided to the appellants on their notification postcard of hearing, as well as on our website. We provide virtual hearing training to our board members, and we have also provided it to our assessor's office staff. All virtual hearing participation information can be found on our website, and we assist members of the public with any special need accommodations that they may have on a case-by-case basis.
The rest of the office is using MS Teams.
I'm sorry?
You mean, our office?
I'm sorry, folks. You need to mute your mics. Okay, go ahead. I'm sorry.
As I was saying, all of our virtual hearing participation information can be found on our website, and we assist members of the public with special need accommodations on a case-by-case basis. At this point in time, I am not aware of any request from the public for any special need accommodations. Lastly, we have invested in basic items like web cameras and headsets. However, in terms of looking for remote hearing capability and efficiencies for the long term, we are going to mirror whatever our Board of Supervisors is currently doing for their meetings. Our thought, as mentioned at the beginning of the meeting, is that we will resume to in-person hearings when available or when approved. However, in the meantime, we plan to continue to operate as we currently are. That concludes my comments.
Thank you. Now we'll close this part out with Ms. Kathy McCullen, clerk from Sacramento County Assessment Appeals Board.
Thank you, Mr. Chair. For technology options, visual and audio interruptions, for Sacramento County, the clerk staff is familiar with remote meeting technical issues and solutions related to connectivity. Dedicated IT staff also assists with technical problems and resolves issues in a timely manner. If an applicant or agent or assessor staff or board member has a bad connection that is not able to be resolved, the appeal will be continued to ensure a fair hearing. Concerning reliable platforms for remote hearings, Sacramento County has approved BlueJeans as its virtual platform. It's currently used for 32 boards and commissions and is reliable. Up to 9 participants can be displayed at one time, and this is sufficient to address each appeal or set of appeals, I believe. The clerk has administrative functionality, including audio and video features. For the next bullet point, notice requirements to parties. General instructions and best practices will be posted on the county's AAB webpage. Participants will receive access information directly by written notification. Optional training and practice sessions will be available to all participants in advance of each scheduled hearing. An attempt to meet all accommodation requests will be pursued as reasonably as possible and evaluated on a case-by-case basis. The final point, investment in remote hearing capability. The BlueJeans platform is the county standard platform, and it is used countywide. And the clerk's office has purchased additional accessories such as webcams and hands-free noise canceling headphones with a microphone capability for improved efficiencies and long-term use. And that concludes my comment.
Thank you. With that, we'll move into the assessor's rep, and I believe it's going to be the Honorable Ernie Dronenberg. Is Ms. Dronenberg available? Ernie.
This is AT&T. I do show that individual is dropped from the event.
Oh, how about Don Gakel then?
Yes, Chair Vasquez, looking at technology
I'm here.
options. I was.
It sounds like Ernie's back.
Hello, Ernie, are you back?
Yeah, and you know, this is like the cobbler who has kids with no shoes on it. I hit the wrong button about 25 minutes ago. It took me, and my phone said 22 minutes to get back in. Then just about 3 minutes ago, I hit another button to mute the phone because of the request, and I hadn't muted the phone right. And now it's taken me another 4 minutes to get back in. So why don't we think about doing Zoom calls where you can jump in and out without a problem for future Board of Equalization hearings?
Well noted. Thank you. Welcome back.
Okay, so that was going to be my comment.
On technology, huh?
Well, technology, we use Zoom in San Diego, and unfortunately, I was listening to the Deputy Chief Recorder from San Diego because she's done a great job so far in all the areas, and so I was going to say that I don't want to be redundant, but I didn't hear what she had to say. But you know, I think it was said earlier from the CADA folks that we should have standard kind of programs for everything. That just does not work. We can't even get standard rules in the state of California. Standard technology is a dream. I'll bet you there's 5 different meeting capabilities that are being used right now, Zoom and Teams and Blue Jeans, and so that's nice, but we got to be flexible with this thing. And what I was going to say before I went on my 22-minute absence was something I came back and it said like, oh, well, we can't come to a resolution on that one. Well, that's good because I was in the negative side on that. So I don't mean to complain, but it's frustrating when you don't have an easy access. AT&T is old technology. So having said that, I'll let I think the Board of Equalization speak next.
Thank you. We're now actually with the taxpayer representative, which is Ms. Brennan Roboski.
Hi, this is Brianne Rabowski on behalf of CADA. And I just wanted to start by saying that, Assessor Dronenberg, we actually agree with you. I think that there's a lot of flexibility that needs to be built across these guidelines that are coming down. And that would include the platforms. I think we recognize that counties have the right to select a platform that may suit their needs. We think that it does need to have certain basic things available within those platforms. We haven't looked at each of them. Blue Jeans isn't familiar to me, but perhaps it has the capabilities that we need. But we do understand flexibility is needed. So I just wanted to clarify on that point. And so I think I'm on the second bullet point, and then I'll go back to the first since I sort of started with that. For purposes of the platform, it needs to be available and accessible to all taxpayers, and it needs to be accessible at a low or ideally no cost to the taxpayer. It should ideally be easy to use, and importantly, it needs to facilitate the real-time viewing and hearing of all participants, as we spent a lot of time on today discussing, which includes of utmost importance viewing of the witness and the exhibit, as well as the board members, to protect due process rights. It also needs to accommodate or have an additional program to accommodate the submittal of real-time evidence as needed. So I think that's pretty consistent with prior discussions that we had. And I apologize, I'll move next up to the first bullet point, which is interruptions. I think we are in agreement with the vast majority of things that were shared with the board thus far. We think that IT support will absolutely be needed, and it'll be needed for all participants in the hearing, including the taxpayer side and witnesses that may encounter issues. So we recommend that IT support be on call as needed. We're also very supportive of the idea that to the extent there is a technology problem, that the participants powwow as they can and continue if it's something that can't be resolved within a reasonable amount of time. To the extent that a technology issue causes the taxpayer not to be able to appear at a hearing, they can't get their technology up and running despite their best efforts, we ask that there be no denial for lack of appearance in that situation. I think we can all recognize that technology at times can stand in the way, and we'll need some flexibility to ensure no denial in that situation. We also reiterate our request that at the beginning of the hearing and perhaps following breaks, that the clerk inform the parties of their due process rights and allow them to request from the board a continuance at any time if they feel like their rights are not being adequately met. Moving on, jumping down to the third bullet point, access instructions, training, and accommodations. We agree that the notice of hearing format should be notified to all parties as part of the notice of hearing, and that there be as much detail provided along with that notice of hearing as possible, so that the parties are prepared to engage in the hearing and are understanding the rules of the game, if you will, as early as possible. Training and instructions are essential. Many of the various board members have discussed trainings for their AAB staff and trainings for their assessor and their clerks. We need to be mindful, we believe, of taxpayers' need for training as well. Many representative parties will be facile with this technology or have in-house capability to become facile with it, but a lot of unrepresented parties will need additional training. So we are very supportive of all parties having the ability to do practice sessions or access to different training materials, videos, access to ask questions to the clerk. We think this will be pivotal, especially in the beginning months as we move to remote for the hearings that will be done remotely. The last bullet point, investing in remote hearings capability and long-term efficiencies. As we've said before, we think that remote hearings should be encouraged for procedural matters, as we've discussed, as well as potentially for hearings that are much more streamlined, less documents involved, less witnesses, less issues. We could see remote hearings being very beneficial for those types of hearings, but again, not for all types of hearings. We also, I won't go into this due to respect of everybody's time, but we do have various ideas to assist in the backlog and how to really realize and increase efficiencies for the long term by encouraging parties to meet before the hearing to discuss the evidence and at a minimum narrow the issues to the extent possible, if not reach stipulations. And so we have some ideas about how to really encourage the parties to come to the table before they're in a hearing position, but I'll reserve that for a later date.
Thank you.
And that concludes the comments.
Thank you. Thank you. Members, are there any comments or questions from any of the presenters?
I do, if I could.
Go ahead, Mr. Gaines.
Just, and it was touched upon by the comments by the presenters, but just the importance of making sure that that taxpayers are able to work in this technology environment. And I'm thinking specifically, poor individuals, and the other aspect would be rural, because sometimes you just don't have access. You don't have enough bandwidth to even communicate in some of these rural parts of the state. So as long as we're adhering to accommodating those that don't have the means, and those that don't have access to the technology because of where they live, I think we're heading in the right direction. And I love the idea about taxpayer training that Brianne brought forward, because with this movement to technology, and I'm convinced it's here to stay, and it's going to be our future. So to the degree that we can make sure that people are trained, just as we've been trained, right? When we decided to have our own Zoom meetings, that would be very helpful, and I think essential for our constituents. So thank you.
Anybody else? I had a quick question. I guess it would be for Kathy McCullen, I believe the clerk from Sacramento. If I heard you right, you mentioned it sounded like you guys were sold on Blue Jean technology in terms of your platform. And I've participated on Zoom, WebEx, and Teams, but I've never done Blue Jean. I was just wondering what is so good about Blue Jean that I'm not aware of.
Well, I can't speak to all of the issues regarding why our county chose that as its official platform for these meetings, but I do know that security was a big concern, and that Blue Jeans is a good option as far as security features. And as far as some of the other criteria for what these platforms need to provide to have an effective meeting, I can't remember who was making the comment, but it is free to the taxpayers, user-friendly. It can be used, through mobile access, or a web link, or through the Blue Jeans app. And it does have the ability to display and screen share, as well as display nine individuals through a video at the same time. And in fact, I watched the Zoom meeting from San Diego last week, I believe it was, and our platform is very similar. I think one of the bigger differences is that it can't show 49 faces at the same time. But for us, for the purpose of just displaying one appeal or appeal set at a time, I believe 9 to display is adequate. And it's been a successful platform for us. And like I was saying earlier, we use it for 32 other boards and commissions effectively.
That sounds good. But it sounds like the capability, in terms of numbers, it's limited though, right? That's what it sounded like.
I think as far as how many people you can display, you can invite 500 people, if I am remembering this correct. So as far as if you're doing a teleconference, you can invite, I think, up to 500 people, but you can display 9 at a time. So, but that would be including the moderators, the presenters, and then you can, and then it also has people as the attendees who cannot participate, but they can listen in.
Thank you. Members, any other questions of the presenters?
Mr. Vasquez, Regina.
Yes, Regina, go ahead.
I was wondering, it sounds like we might have a little bit more consensus in this section, and just curious from the members' perspective, allowing counties or setting forth some guidance that allowed counties to pick the best platform based on their needs, priorities, review, security, all of the above could be one area. And I think we're hearing across the board that the members of the work group will find that valuable, and as well as the ease for the user, right? We would also want it to be user-friendly. And then just wondering if the members, board members as well as work group members, sort of believe the first bullet, if there are, and I think we spoke to this in an earlier discussion, if there are interruptions just based on technology challenges, that either the parties would collectively agree to go forward or a continuance would be provided. And then last but certainly not least is just making sure that we provide some guidance that ensures that the notice requirements provide access instructions, provide for training and coaching opportunities, as well as any kind of special accommodations. And just am wondering first from the work group and then maybe for the members if we see some consensus in that space. Because I think, if I'm hearing everybody correctly, there may be some opportunity to get there. I'm just curious of where the work group members are and then, of course, the board members.
This is Marcy Berkman. I agree with that discussion.
Others?
This is Marvise Mazik from San Diego County. I agree with that as well.
This is Kathy McClellan, Sacramento County. I agree.
And this is Jennifer Tran with LA County. I agree with that as well.
There he is.
And Brianne Rabowski on behalf of CADA, we are in agreement as well.
So just go through it, cut, chop.
Well, it looks like we have unanimous on one finally, huh?
I didn't have this many pages.
I know, I went through it and I cut down a whole bunch.
Don't forget, folks, if you're not speaking, you need to mute your
I
mic.
went on both sides. I missed that whole paragraph out.
Yeah, I deleted most of it. It had a negative next to it.
How about the member?
Chairman, this is
Oh, I'm sorry, go ahead.
I was going to move on to a related item under this topic, but I can wait until the members have had a chance to speak.
I restructured a little bit. You'll see where it says your assertion is a fact.
Mr. Vasquez, can we take a break and allow the member who is not on mute to be addressed?
I think that's Henry. I believe that's our counsel.
Is that Mr. Nanja?
No, it's not I. I'm muted.
Oh.
Hello, members. I've just sent a note to Mr. Jonerberg to try to get him to mute his mic.
Oh, it was him. Okay, it was him. Do the members need, are they?
Sorry about that, Mr. Nanjo. This is Ted.
Member Gaines, did you have a question for me?
I just apologizing. I'm sorry. I thought that was your voice I was hearing.
Oh, no, not a problem. Kind of hard to tell voices on the conference call.
Yes. Do any of the members want to weigh in? It looks like we have a consensus on this one, unless I'm hearing from the members. Hearing none. Ms. Davis, do we have anybody in the queue, or does AT&T have anybody for public comment on this?
Board Proceedings has not received public comment, but AT&T, can you please check to see if there's anyone who'd like to make a public comment on this item?
Certainly. If anybody on the phone would like to queue up to give public comment, you may press 1, then 0 at this time. Does not appear there's anyone queuing up at this time.
Thank you.
Thank you.
Go ahead, Mr. Chairman.
So it looks like we're able to move on. Now, I guess I'm just going to ask the members more of a time management. We're at 3 o'clock now, and I understand we have a drop. I think the latest we can go is 4. Is that right, Steph?
That's correct.
Do we want to get into the next item, which is the BOE role, letter D?
I'm willing to continue for, this is Yvette Stowers, I'm willing to continue for it as long as we complete our job before 4 o'clock.
Vice Chair Schaefer, I agree with Ms. Stowers. Okay.
All right, so why don't we go ahead, and then with the understanding if we run over, we'll just wrap up the conversation. So this is the BOE role, and it's basically, it's the invited work group speakers. We have 2 BOE staff representatives, 4 county AAB representatives, 1 assessor representative, and 1 taxpayer representative. Here we got 5 bullet points, starting with the first one: possible modifications needed to property tax rule 301 through 326 to facilitate remote hearings. Second bullet is details on guidance needed to ensure uniformity on resolved remote hearing issues via letters to assessors and assessment appeals manual. Bullet 3 is provide training for AAB members and staff, assessors and staff taxpayers, and other participants, including but not limited to the use of technology and equipment required for remote hearings. The fourth bullet here is clearinghouse function, ensuring information and communications among all counties, assessors, taxpayers is received and shared. And then the last one is publish letters to assessors, to county boards / AAB clerks, county councils, interested parties, providing guidance on resolved issues remaining and concerns. With that, we'll start with our first speakers we have for this one. We're going to start with BOE first, and we have David Young. If we can have David Young start opening up for us first.
Yes, good afternoon all. This is David Young, Deputy Director for the Property Tax Department. If it's okay with you, I think I'm going to share this duty with Mr. Richard Moon of our legal department. So I'm going to put you on deck, Richard. Sorry. But I'm going to leave the first bullet point to him, the modifications of property tax rules 301 to 326. I know we will be looking at those and taking a look at which ones needs to be modified, if any. But I understand that we are trying to get guidance out a little sooner than we can probably make a property tax rule amendment or promulgate a new rule. As to the details on guidance needed to ensure uniformity on resolved remote hearing issues via letter to assessors and assessment appeals manual, both of those options are readily available. Staff has been taking copious notes on the items that were discussed, and thank you all for your valued input on those. I think we've captured a lot of it, and we can work on an LTA. An LTA will be turned around much faster than an assessment appeals manual. The assessment appeals manual will definitely be a little longer term project, but if the desire is to get guidance, at least initial guidance out, then I think the LTA would be the avenue to go through. I'm just going to go through all the bullets, if that's okay with you first, and then maybe we can have Mr. Moon circle back on number 1 or add to it. Providing training for AAB members and staff, assessors and staff, taxpayers and other participants, including but not limited to the use of technology, equipment, and remote hearing. that is I definitely think that is a needed element. The board currently does provide some training on assessment appeals. It is available on our website, but it is not specific at all to remote hearings. It is AABs and in general. So as to providing training on technology and equipment required for remote hearings, the general discussion, I think the consensus is that there is need for flexibility for counties to choose the platforms and the technologies and equipment that would best suit their needs. So on that one, I think the bulk of the training would have to be perhaps on the county level, since it is their equipment, their platform, and their training. Some of the other stuff that are a little more widespread, like maybe, we work with some WebEx, and we work with some Zoom. Well, actually, we do not work with Zoom. We work with WebEx, and so we could be a resource there. But I think a lot of that will have to be county specific. For the clearinghouse functions, I can see the board being a clearinghouse functions for, I know there are counties already. We've already mentioned San Diego, Sacramento, Riverside has a hybrid, and I believe there's another county that was mentioned that already started having remote hearings. So if they are willing to share any of their procedures, their practices, any enabling resolutions they needed to adopt, or a local ordinance that they have adopted in order to have remote hearings, we'd be more than happy to be a clearinghouse, a repository of that, and make it available on our website for other counties that are considering having remote hearings. And let me see, the very last one, publish letters to assessors, to county boards. I think that one will be fairly similar to the bullet point number 2. We'd be more than happy to work with all parties in getting a LTA out on guidance and summarize some of the unresolved issues that still need further developments, further vetting. Mr. Moon, do you have anything you wish to add to either number 1 or any of the other 4 bullet points that are on this issue, on D?
Good afternoon. This is Richard Moon with the legal department. I'll just add a few things to what Mr. Young had shared. First, of course, as everyone's aware, the general role of the BOE here is to provide rules to the Assessment Appeals Board that govern or that guide in the conduct of remote hearings. And in considering that our role with regard to that responsibility, I was glad to hear many things, I think, that demonstrate that all the parties understand what our roles are. And so I guess I wanted to just make clear sort of our thought process as we begin to draft and think about what would go into an LTA. And of course, we have our responsibility for uniformity, and of course that needs to be balanced against the need for the counties to be flexible. And also, we recognize that the existing rules governing the hearing procedures should mirror as closely as possible the rules that govern in-person hearings. And then finally, we want to also consider the appeals board's authorities to conduct any specific hearings according to its judgment as their needs arise. For example, there was some talk about continuances if there were technical problems with a remote hearing, and we think that's of course appropriate. The only specific thing I would add is that with the first bullet, possible modifications needed to the property tax rules, I don't think I heard anything today on which there was a stated consensus that would absolutely require a rule. We could, especially as we think about long-term after the pandemic, think about changes to some of the rules to make it clear the differences that would be needed or would be desirable when a remote hearing is held, as opposed to when it's in person. And again, sort of general topics that we may consider are the ones that we discussed here: due process, submission of evidence, and various technological issues. But in terms of issuing guidance in the form of an LTA, I don't think anything that I heard again on which there was consensus would absolutely require a rule. And I'm happy to take any questions.
Thank you. With that, let's go ahead and move on to our County Assessment Appeals Board representatives, and we'll start with Ms. Berkman first.
Hi, thank you. I agree with everything that both of your legal counsel recommended in terms of that. In terms of potential property tax rules that the board might want to consider in the longer term, and I agree that an LTA coming out first is the appropriate way to go with the current situation and time limitations. If the board later on decides that remote hearings should continue for the longer term, some potential places where it might want to consider modifying the property tax rules would be to add a definition of remote hearing to Rule 301 that, for example, might just potentially mirror AB 107. In Rule 312, that rule addresses the official record, and it's possible that the board might want to consider adding a subsection to that rule saying that counties should have a local rule specifying what constitutes their official record in situations where there's a remote hearing. It's also possible that the board might want to just do that via LTA. For Rule 317A, that currently says the applicant must appear personally at hearing or be represented by an agent at the hearing. It's possible that the board in the future might want to add a subsection to that, similar to AB 107, that just clarifies that that includes appearing by telephone or by video in telephonic or video remote hearings that the county is conducting. And then Rule 323, I believe as it is, covers the situation for postponements and continuances, including the pandemic. I like the board's earlier suggestion that it include in the LTA that the pandemic is good cause for a postponement, and something that the board might want to consider in amending the rules in the longer term would be including something like along those lines, that a pandemic or other emergency of that sort would constitute good cause for a postponement. Thank you.
Thank you. With that, we'll move on to Jennifer Tran.
This is Thomas Parker from Los Angeles.
Thomas.
I've been deputized. No, that's not a problem, Mr. Chair. First of all, I would, on behalf of the LA County AAB, I would just like to advance the notion that whether it's an LTA or down the road formal regulations, and we have no problem with an LTA, by the way, at this point in this process. The state board should not really seek to over-regulate remote hearings, just as in-person hearings have been historically not over-regulated. Local AABs need reasonable flexibility to tailor how remote hearings are to be done in their jurisdiction, because one county does not equal another in terms of their resources and workload. The consistency argument that I've heard over the many years I've been with the state board, not relating to remote hearings, but to various other aspects of state board regulation or potential regulation, focuses with a good deal of excessiveness on the terms uniformity. The The fact is, as has been said, we are quasi-judicial, constitutional quasi-judicial administrative bodies. You have 58 local superior court rules in the state of California. And if you're an attorney who practices theoretically in all 58 counties, you're going to have to make sure you know what the local rules are in the county you're in on any given case. I respectfully submit that the same would apply to practitioners, whether, tax lawyers and tax agents, if they theoretically practice in 58 counties, which, to be honest, I doubt, but theoretically, they need to make sure they know what the local rules are in the jurisdiction where they have a client, because they have a responsibility to properly represent their client, the taxpayer, and get the best result that they can for that individual or corporation. As far as the local rule, the state rules that at some point might be looked at, in addition to the rules mentioned by Ms. Berkman, I would offer up looking at Rules 309 in terms of authorizing remote hearings, exceptions to remote hearing scheduling, time waivers associated with remote hearings, and document submission requirements. And Rule 305.1, discussing when documents exchanged pursuant to Rev and Tax Code 1606, and Rule 305.1, if amended, shall be electronically submitted to the board clerk. So those are my comments. Thank you very much. And on behalf of the Los Angeles County AAB, I want to express our appreciation to this board for putting all the time and effort into this process, listening to everyone, asking very good questions, and considering all of this material very carefully. Thank you very much.
Thank you. With that, we will move on to Ms. Mazik, Chief Deputy Clerk from San Diego.
Thank you, Mr. Chairman and members of the board, for hearing me one final time. Hopefully you all can hear me well. For San Diego County, we are also in agreement with the comments and concur with the comments that were made by Santa Clara and Los Angeles. The only other caveat that I would have for the rules to be considered would be the Rule 307A for notice of hearing to include the electronic delivery of the notice. Outside of that, with regard to the LTA, I think that would be beneficial, and we'd be in favor of that in order to expedite guidance at this point. And we, of course, are in favor of any training that we can provide to AAB members, staff from the assessor's office, our own clerk of the board staff, as well as training for appellants and taxpayers. And if that's something that we can provide online through our website, that would be great. Also, if it's something that can be, if information can be disseminated through the State Board of Equalization's website through a clearinghouse function to ensure that all counties receive consistent information, we would be in favor of that as well.
Thank you. And now we'll move on to Kathy McCullen, Clerk from Sacramento County Assessment Appeals Board.
Thank you, Chair. Sacramento County doesn't have a written statement on this portion. I apologize. So I echo what Ms. Mazik just commented and Mr. Parker, and just looking forward to an LTA to provide guidance for the short term.
Thank you. With that, we'll move on to our county assessor's representative. And is this going to be Don or is it going to be Ernie?
Well, this is Don Gakel. I don't, Ernie, are you there? Okay, this is Don Gakel, Stanislaus County.
Go ahead.
I'll wrap up. I very much appreciated the comments of the Assessment Appeals Board representatives and county councils with Santa Clara, Los Angeles, San Diego, and representatives from Sacramento County. I think as I read through these bullet items, I really think most of the information necessary to process these bullet points was kind of gleaned through the other discussion in the other sections. I think it's important to note that we very much, as assessors, appreciate the LTA process to provide immediate guidance and standardization as much as possible around the state. But I think it's important to recognize that I think the cat's out of the bag here, and virtual hearings are going to be. I mean, virtual business is going to go on for a long time. So I think that the long-term goal of modifying the rules is very important to keep up with. But in the short run, we certainly support the LTA process and look forward to being able to review a draft of that. And I appreciate the board having this hearing. It's been very enlightening to listen to, and thank you very much.
Thank you. Now we'll wrap up with our taxpayer representative, Ms. Van Robuski, the chair of CADA.
Hello. So I'm happy to be able to wrap up on what looks to be another very close to consensus item. Many of the positions that we have align with things that you've heard from the BOE and other representatives today. So I'll just run you through them very quickly. We agree that in the short term, the LTA is the best approach because it's the quickest approach. Ideally, it would be followed by assessment appeal manual revisions, perhaps an additional chapter to address remote hearings. And to the extent that remote hearings are here to stay for the long term, we agree in that position, the rules should be considered, revised, and clarified so that they're consistent with remote hearing expectations. If it's simply a short-term solution, we think that a rulemaking process would take too long, even in the form of an emergency regulation. So once the rules are considered, I agree with the rules identified by Santa Clara County, needing revisions as Ms. Berkman has suggested. I think most of the suggestions to the rules on 309 and 305.1 by LA County are things that should also be considered. We'd, of course, need to see a draft of exactly how that would be done. I further agree that 307A, as recommended by San Diego County, notice of the hearing should be considered. And I'd like to supplement her suggestion with the suggestion that the notice of hearing specifically have to require the format of the hearing. Is this remote? Is this in person? And that it provide detail around the platform, the procedures, and the protocols that will be used to the extent that it's a remote hearing. Also, we'd need to look at Rule 316 in the same way we would look at Rule 317, in that it has several references to attend and appear that would likely need to be updated to clarify that that could be attendance or appearance remotely. I think that concludes the rule side. We further agree that training is essential, and the BOE's role as a clearinghouse is an important function for the BOE to take so that taxpayers and other counties can see what other counties are doing so that there is some level of consistency throughout the counties and access to information. And I think that covers it all, Mr. Chairman.
Thank you. Members, it sounds like we have a consensus on this one as well, but let me open it up to members. Any comments?
Vice Chair Schaefer, I have no comments.
Member Gaines.
I have no comments. Thank you.
Regina. Hearing none. Oh, I'm sorry. Go ahead, Regina.
Mr. Vasquez, I do have a question, but just before we close.
Well, I was going to take public comments, so go ahead.
I'll wait till after public comment.
Okay. Do we have any?
Yvette Stowers here. I have a comment.
Oh, yes. I'm sorry. Go ahead, Yvette.
Okay. Yeah, I believe staff commented about if the AABs of the counties are willing to provide information that we could gladly put it on our website. My comment and concern, I think that's a great idea for us to house that information, but I'm just wondering about the cost because we will have to make that accessible. You know, that process, everything must be accessible on our website as far as the font and the size. So we might need to look at that a little closely before we make that commitment.
I agree.
Okay. That's it. I just wanted to make sure that my voice was heard. I'm here, actively participating.
Thank you. Thank you.
Thanks. This is Brenda Fleming, Executive Director. Duly noted, and it's a note that's on my list we'll talk with staff about it. Thank you.
Ms. Davis, do we have any written comment before we go to AT&T?
We've not received, the Board Proceedings Division has not received any written comments.
Okay.
So we can go to AT&T.
Okay.
Ladies and gentlemen on the phone lines, if you'd like to queue up at this time, please press 1, then 0. We do not have anyone queuing up at this time.
Well, with that, I guess we're pretty much wrapped up. Let me give some closing remarks, and then I'll open it up to the other members to see if they have any closing remarks as well. First of all, I wanted just to thank not only the members, but all the presenters that we had today and the public that was listening in. You know, this was, I know, a little bit long and sometimes a little lengthy in our discussions, but I think we had some real good suggestions. And there were certain things, obviously, we couldn't get consensus on, at least not right now, but I feel pretty good about the direction we're heading. And specifically on the last two, I guess, panels we had, it seemed to be, at least from the discussion and the views, the consensus seemed to be a little bit stronger. And we're hoping to, and I know staff is working real hard, we'll get this back, especially for the first two. I'm thinking of A and B, to come back where we could possibly have this at a later meeting and come back and see if we can't arrive with some consensus, or if nothing else, some suggestions and some options for us to consider moving forward. And with that, let me just open it up to the other members if they have any closing remarks before we close out. Actually, we're not going to officially adjourn today. Once again, we'll recess until tomorrow and continue this meeting, or the next, I should say, part 3 of this meeting, and then adjourn after tomorrow's meeting. But with that, let me open it up to the other members.
This is Vice Chair Schaefer. I want to say it's been a very helpful meeting, and we've learned a lot, and we've resolved a lot of disputes. And I want to thank everybody who spent the day with us for being with us.
Thank you. Member Gaines?
Yeah, thank you. I think it was a very productive meeting, and I just hope that we make sure that we're keeping in mind the taxpayer through this whole process in terms of, I would not say following due process at a minimum level, but doing it at the right level to make sure our constituents are properly represented. And when we talk about remote hearings and using technology, the folks that fall out on that are folks that can't afford it. And I would say, coming from my district, certainly rural parts of the district have bigger challenges in terms of getting technology. So addressing those issues in my mind is really critical. And I think what we're doing here is we're really setting a template for the future, because if things move forward with the governor's the legislation at the governor's desk, as mentioned by Member Stowers, then remote hearings are going to move forward into the future, and I think it'll become the norm. So I think it's incumbent upon ourselves to make sure we do it right. Hopefully the first time. I guess we can always take another look at it down the road too, but I'd like to give it the best shot we can from the beginning. And so I just want to thank the board and all the participants. Want to thank Chair Vasquez and Member Cohen and Ms. Evans too for all the work you put into presenting this today, and I thank you for that.
Thank you. Regina, I believe you had some comments closing on behalf of Ms. Cohen.
Thank you, Mr. Vasquez. I, too, on behalf of Ms. Cohen, would like to thank the board members, would like to thank the members of the working group who spent all day with us, as well as BOE staff, taxpayers, practitioners, all involved in this process. Today has been extremely helpful in providing feedback for the board members and the agency as we start down this path of establishing guidance. And I want to say to the assessment appeals boards and the assessors, thank you for coming to the board and asking that we lead this process. We heard you loud and clear, and I think today is an example of how valuable this process is. I am hoping, though, before we close, only because this is a public meeting and we don't always have the opportunity to hear directly from you collectively, but Mr. Vasquez, I would ask that we allow all the working group members as well as any board members to share with us if there is a topic that we have not covered in the agenda today that you would like us to consider for future work group meetings related to remote hearings, and would just love to hear from everyone. We are taking notes, but it will help us as we continue to plan. We certainly heard the things that you brought up today, but I'm believing there may be other items that we have not captured to date that you would like us to cover. So, Mr. Vasquez, if at all possible, I would like us to hear from each work group member if there's an issue that we have not addressed that they would like to be on future agendas.
No, I think that's a good point. I'd love to hear from, especially any of the presenters that are hopefully still on the line. By all means, if you're willing to share any topics or areas that maybe we need to consider in the future.
This is Brianne Rabowski again on behalf of CADA, and I just reiterated something that I sort of previewed at one point, I believe, under agenda item B. But we believe that there are many different efficiencies that would go hand in hand and really assist with not only remote hearings, but some of the backlog that certain counties are experiencing. And those center around scheduling and the mechanics of scheduling to ensure that taxpayers and the assessor are available on certain days, and that to the extent appropriate, days be scheduled consecutively or scheduled on days where everybody knows they're available, rather than having to go through an extended postponement period. So we have ideas about how to streamline scheduling. We also have ideas about potentially building in something akin to a meet and confer process, where the parties are really encouraged to come to the table narrow issues, consider evidence, potentially reach a stipulation, we believe that that will really decrease the number of appeals that need to be formally set for hearing. So we're looking for an opportunity to share those ideas, which also the third point would be that perhaps pre-hearing conferences could be used in a similar format, although we recognize those would require additional board time. So we think those three items would be really beneficial to consider hand in hand with remote hearing.
Thank you for those suggestions. Anybody else out there? Hearing none. I would like to ask Brenda, actually, from the staff, if she has any comments before we go into recess for tomorrow.
Well, thank you. This is Brenda Fleming, Executive Director. Chairman Vasquez and honorable members and all of the AAB's assessors, CADA, and all others who participated. We really, really do appreciate the time that you've shared with us, all of your input. Members, again, I applaud you for your leadership in this area and really moving forward, these really important issues and conducting this in this public policy, public forum to allow transparency to this process and really bringing in a great audience and participants in the discussion. We are happy to serve in our role to assist in this manner by drafting some guidance. We will be working on that, at least having our initial discussions this afternoon to see what might be possible, even if it's perhaps if feasible, to see if we can get something in the form of an outline that we might be able to share some of our initial thoughts. We'll see what we can do. I'm not actually making a commitment for fear that staff behind me might throw me under the table here. But again, it's our pleasure to participate in this. I think this is going to be an issue that will is worthy of some additional discussions. So at the board's pleasure, we'll schedule some subsequent meetings to flesh this out more, to give the AABs, the taxpayers, and all the parties that participate in this process the best that we can do to help make this these events and these activities successful as we endure this time of pandemic. Certainly there's discussion about perhaps having some of these go beyond the pandemic, but that'll be part of what I call this group, our community's discussion, and we will do that which is best to serve our public. So again, thank you, members. It was a great day, great discussion, and again, we appreciate your leadership.
Thank you. Actually, I would just, we're not closing, like I said, this is just a recess until tomorrow. But,
Chairman Vasquez?
Oh, yes, Ms. Stowers, go ahead.
Thank you. On behalf of Controller Yee,
oh, yes,
I would like to thank all the participants for today's meeting, especially the tax agents and consultants, the Assessment Appeal Board members, and the assessors, staff, and all of our members. It was a great day, very useful information, and it's nice that we can all have an opportunity to be heard and seen, at least seen virtually. Thank you.
Thank you. And I just wanted to once again thank not only the members, including Regina, who stepped up to the plate to weigh in on behalf of Member Cohen, but also my staff, Kari, and we had Jean, of course, Juan, all the folks, and many of the BOE staff, from Brenda on down, Dave Young, and especially the folks that did present for us, Mr. Moon. I really appreciated the fact that you were able to weigh in and give us some good ideas and some good guidance moving forward. And I'm looking forward to these potential LTAs down the road, and hopefully looking at some possible rule changes that hopefully will make it better for the taxpayers, because I think at the end of the day, and listening to everybody, it sounds like, this is going to be the new norm for a while. Everybody was kind of thinking things were going to go back to normal sometime soon, but I don't see it happening, at least for another year and maybe longer. So I think whatever we can do to make the necessary adjustments to make it as palatable as possible, specifically for the taxpayers, we should do that. And with that, we will go ahead, and we're not adjourning, we're just recessing until tomorrow at 10. This is our 3-day marathon, and I want to thank all the members for hanging with me on this. I know it's been a long, well, so far 2 days, and we still have one more to go. Thank you all, and get some rest, and we'll see you in the morning.